If you're negotiating a major Oracle deal or you're litigating against Oracle, there's a new case you need to know about. That's what I want to talk about today. My name is Marcus Harris. I'm a software and technology attorney. For over 20 years, I've drafted and negotiated a variety of software-related contracts and litigated failed software projects in courts across the country. Barrows v. Oracle is a new securities class action case, and the complaint focuses on Oracle's public story about its AI infrastructure build-out. Oracle heavily promoted large capital expenditures for new data centers that were supposed to support its AI initiatives. Essentially, Oracle basically said those investments were going to quickly and rapidly translate into accelerated revenue and profits, and that just wasn't the case according to this lawsuit. So what can you learn from these allegations, and how does it impact you as a customer? And I think the reality is that this case isn't only about abstract financial metrics, it's also about Oracle's AI initiatives and how soon those AI initiatives are going to come to reality. The lawsuit suggests that Oracle's AI strategy and cloud infrastructure may be more sensitive to large debt-funded capital expenditures, delays or bottlenecks in bringing new regions and AI capacity online, dependence on a concentrated set of marquee AI and government customers, and tighter free cash flows and a heavier reliance on external financing. So what are the practical steps you need to be aware of as you're negotiating an Oracle deal in light of the Barrows v. Oracle case? Oracle's AI infrastructure really isn't all that it makes it out to be. I think when you're negotiating with Oracle, you really want to focus on implementation and capacity milestones. You want to really focus in that negotiation on SLAs and remedies that match your risk profile depending on what you're relying on Oracle to do. Certainly, if you have bought into Oracle's representations about its AI capabilities and you're in that product environment and you're going to be relying on the product roadmap, I think you want to make sure that that is a reality and that you've negotiated language that accounts for it not coming to fruition. You want to have an understanding of what protections are in place in that contract with Oracle regarding financial and credit related issues. You're going to want to nail down with a very high level of specificity AI features and timelines in writing. Those need to be detailed in the contract. And I mean, if AI is really central to your business case for utilizing Oracle, you're going to want to document it. You're going to want to define the specific features, performance metrics, and target timelines that are important to you and to your business. And whether that's in an SOW, whether that's in the base contract itself, I don't think it's going to matter very much with some caveats, but it's got to be in that agreement, and you want to make sure that you're holding Oracle's feet to the fire. I mean, if it's going to be marketing and promoting this robust AI initiative and its future performance based on its current financial investments in AI infrastructure, then it really shouldn't have much of an issue putting that kind of detail in the contract. I would expect pushback, of course. Taking it back to the piece of litigation, what does this case not do? At least not yet. You should be clear, Barrows v. Oracle doesn't necessarily negate every optimistic AI representation that Oracle has made, but as discovery unfolds and additional disclosures are made, the factual record around Oracle's AI strategy, its project timing, and its financing could very much be on the table. And I think that is going to be a useful backdrop to customers, whether they're negotiating with Oracle or if they're involved in another piece of litigation with Oracle, and Oracle's made representations about what it can and can't do. Certainly, this is an insightful case, and I think you need to know about it and you need to use it to your advantage, whether that's in litigation or in a contract negotiation. If you have any questions about anything that I've talked about in this video, please feel free to reach out to me. I'd love to talk to you and point you in the right direction.